I'd like to introduce today's speaker. Lori Chesser is with the Davis Brown Law Firm and is the chair of the firm's immigration department. Lori has been practicing primarily in immigration law in Des Moines for more than 20 years. Lori assists in both employment law and family-related immigration topics. Her clients include small and large businesses. I'll turn it over to Lori.
Thank you, Christy. Welcome, everyone. So this is a very timely seminar because, of course, just, well, really Sunday, we have a new travel ban from President Trump, so we'll cover that today, and I hope you all received the updated PowerPoint that we sent to include the information on the new travel ban. But we also have a lot of other things about immigration in the news, and if you are practicing in this area or you have interest in it for your employees, if you're in-house counsel, I think there's a lot to keep track of. So we'll jump right in. I would welcome questions as we go through. When I get to a good stopping point in a topic before I move on to the next one, I will ask for questions. So feel free to submit those, and we'll try to answer those as we can going along. And then, of course, you'll have a chance for questions at the end as well. But I just don't want to lose anyone as we go along. And there are a lot of topics, so we'll go ahead and get started. Well, until the new travel ban was enacted, the biggest thing in the news was DACA. So I started with DACA. So we'll go ahead. We'll go ahead with that. I'm sure you've either know about DACA or heard about it in the news. Just as a reminder of what we're talking about, DACA stands for Deferred Action for Child Arrivals. It was an executive order issued by President Obama in June 2012. On this slide, I go through the requirements for it, but basically it is people that arrived before age 16 and were under age 31 when the executive order was announced. They either need to be in school or have graduated or gotten a GED or honorably discharged from the military. And of course, no convictions, serious crimes. There was a lot of vetting going on of these applicants. Now, DACA is not a grant of immigration status per se. It was just an opportunity for people to register, and they would, of course, give all their information to the government. And to prove that they qualified, they had to provide records, such as student records, school records, or work records, or different things, to the government. And in return for that, the Immigration Service issued them a 2-year work permit. Now, those, of course, have been renewed as the program has continued. Now, that work permit, or we call it the Employment Authorization Document, or EAD, I'll be referring to it in the presentation, EAD, that would allow the people who receive that to obtain a driver's license in Iowa, and I think in all the states they were allowed to then receive driver's license. Did not qualify for federally funded scholarships, but definitely could enroll in school, which they could enroll in school anyway, but there were some other scholarships sometimes available. The other thing that DACA allowed people to do in certain situations was obtain advance parole. Now, advance parole is a travel document. It allows the holder of the advance parole to leave the U.S. and re-enter without a visa. And when you do that, you're paroled into the country. And so in certain situations, if the person had sponsorship in the right situation with a relative, or perhaps with an employer, more likely with the relative, having been paroled, they could then apply for adjustment of status. Now, adjustment of status is the application for a green card that's made when the person is in the U.S., either lawfully admitted or paroled. So that was a way that some people got on the track to green card through DACA. But, I would say most people didn't qualify for that, but some people did, and some people were able to use that, even though it was a very risky strategy. Now, as you also have probably heard, that executive order was rescinded on September 5th. Whoops, and I have 2015, which is totally wrong. It's 2017. I don't know why I wrote that, but in any event, we'll correct your slide. And so what they announced was that renewals would be possible for DACA only for those whose work permits or EADs expired on or before March 5th of 2018. To get that renewal, they have to apply by October 5th. So in other words, in a few days, they need to be able to have that application pending. So that's a big takeaway, is to make sure if you know anyone who's DACA and who falls in that category, they definitely have to send in their renewal by October 5th. Otherwise, they will not be able to renew it as it stands now, and anyone whose work permit expires after March 5th is not able to renew it at this time. Pending applications for DACA, either initial or renewal, would be processed if they were filed before the announcement on September 5th. Pending applications for advanced parole, however, will be closed and refunded. They're not going to give any more advanced paroles. New initial applications will, of course, be rejected as well, because the program really is over, so to speak. Now, in terms of advanced paroles that are existing, whether those would be honored, they left that to the discretion of Customs and Border Protection, or SEVP. That's the part of the agency that controls the borders. So if you have people that are outside on advanced parole, they can certainly and should try to re-enter, but it's just not a sure thing. Whether you advise, I think it'd be risky to advise anyone to travel now, but of course that's their decision. But it's going to be riskier now that the executive order is rescinded. The EADs, the employment authorization documents, are valid until they expire. So for that reason, it's not an employment verification event that this was rescinded. In other words, if you're employing someone under DACA, you don't need to you don't need to terminate them because it's been rescinded. Their work permission is still valid until the expiration date. You don't need any additional documents at this time. If, of course, at the time that expires, you will need to ask for additional documents. And if the person doesn't have documents, then that, of course, would be a termination event. Now, can you, as an employer, plan ahead and, because you do have to staff, make sure your staff is going to be there. It's certainly fine to remind employees that if they can renew, they should, and especially now the deadline's really close, they need to do that. One thing we are seeing is that there are Notarios, which is sort of the unauthorized practice of law that is out there in the immigration field, taking advantage in certain situations of this situation. So it's important that someone who has DACA consult with a qualified immigration attorney, because sometimes people with DACA would have some other relief, some other benefit that they could access, and they need to make sure of that. So I do have some companies that are having us look at that for their employees and paying for that, which I think is just fine. They're authorized to work now. We know the situation. There's nothing wrong with having your employees checked and helping them to do that if they're important to you. Now, one thing, how do you know if someone has DACA? Well, of course, you don't want to assume that someone who looks or speaks or acts a certain way is in DACA category. It's certainly not all people from Mexico or Central America. There are people from a lot of different countries that have taken advantage of DACA, and just because someone is foreign and young doesn't mean they are taking advantage of DACA. But there is a way you can know if you keep your documents, copies of documents for I-9 purposes. The only document they really could have given you was the EAD, and on the EAD is a code for each classification. In this case, DACA is C33. So you can know, and of course a lot of times employees are forthcoming about that, but I just caution you that in terms of employment anti-discrimination laws, make sure that you're approaching this in the right fashion and consult your employment lawyer regarding that. I've had some employers ask me, is there a way they can help sponsor someone who is DACA? We've thought about that and talked about it with others, and it seems like there could be some narrow situations where that could work. if the person obtained DACA less than 180 days from the date of his or her 18th birthday, they would not have enough unlawful presence, as we call it, a technical term, unlawful presence, to make them subject to the immigration bar. And if something could be processed for them, either a work visa potentially or a green card application, employment sponsored, that would allow them to immigrate. I mean, basically they'd have to leave the country to pick up something like that. They wouldn't be able to change status or adjust status here, but they would need to leave the country, so you'd have to have less than 180 days at the end, after the employment authorization expired. So in other words, you can't have more than 180 days unlawful presence, or you'll be barred from immigration for 3 years. So, the fact that the person would have to leave the U.S. to do that could trigger those bars. It's a risky kind of risky, but it's an unusual strategy, and something that you would want to make sure you were working with someone that knew what they were doing on that, or that you know what you're doing on that, and make sure you're careful about that, and you really study those unlawful presence bars and how that's counted, and understand the person's status. But, in the very unusual situation, perhaps that would be one of the remedies that could be screened for employees who now have DACA. There has, of course, talk of legislation. So if this is something important to you or your clients, it's definitely a time to contact Congress about this. Contact your congressional members if you are in support of that, because what President Trump basically said is we need to give Congress time to fix this, and seeming to hope that they will. So we hope that that will help some of the people that are caught in this situation. So that's what I have on DACA. I'd be glad to take questions on DACA if there are any out there, Christy. Okay. All right. Well, feel free to ask more questions on DACA if they come to mind later. All right. Well, now we'll go to the new travel ban. As a reminder, and this has been a hard one to follow too, because it's, I think, it was on Executive Order 2.5, I guess, before this new one, so I guess this is 3.0, on the travel ban, and a lot of litigation and a lot of different things were happening. But just to remind you where we were, the travel ban originally addressed 7 countries that I have listed there. Iraq was later removed in the second one, I believe, because they said it would be helpful to our involvement in Iraq to have that removed. The various courts at various times enjoined implementation, and eventually ended up before the Supreme, well, was argued before the Supreme Court, but the Supreme Court reviewed at some point and said that for persons with a bona fide relationship with a person or entity in the United States, or who have a valid visa or green card, the executive order could not be implemented against them. So that's sort of where it stood. It expired on Sunday, September 24th, and there is a separate ban, just as a reminder, on refugees, that also the same exception of the bona fide relationship with a person or entity was enjoined on that too. But in any event, that doesn't expire till next month, till October 24th. So I assume we'll have something else on that. But anyway, it was set to expire, and then we have a new travel ban. And by the way, the Supreme Court arguments were canceled, so that's all moot now. So the new travel ban was issued on Sunday. And what happened behind the scenes on this as part of the executive orders was an effort by the Department of State, Immigration Service, other agencies, the Department of Justice, did basically a worldwide survey. And so they sent out to every country in the world to see how they, what steps they had in place to verify identities, say in passports and things like that. And then secondly, how they share information on security and public safety threats with the U.S. So they sent out these sort of questionnaires and, you know, engaged in this in information collection with all the countries. And they said countries that don't comply we're going to have repercussions. So the result of that effort was that they added 3 countries, Chad, North Korea, and Venezuela, to the list. They removed Iraq permanently. They removed Iraq, even though, I shouldn't say permanently, this is a fluid situation, but Iraq did not meet the requirements. However, they said, again, because of our ongoing relationship and attempts to, you know, to work on that situation there, they didn't want to have Iraq on the list. So Iraq is not on the list. All the other countries, that's original 7 minus Iraq, so those 6, are on the list. So for the countries that are new, the Chad, North Korea, and Venezuela, the ban does not go into effect until October 18th. The rest of the countries, it is immediately effective. However, it's not like the first travel ban in that it was a ban of everyone unless you fell into an exception. In the new travel ban, it is by country what your ban is. So in some countries, it's just business visitors, or, you know, B1 or B2 visas, so visitors for business or pleasure. For some, it is everyone. North Korea is everyone. You know, Syria is everyone. And in Venezuela, I think it was sort of government officials and visitors. So there's different criteria for each country. You have to then consult the actual presidential proclamation for that language. Someone pointed out to me that some of the summaries that are out there by Department of State and others aren't necessarily accurate, so you want to make sure you read the presidential proclamation. That'll probably be, you know, fixed, but because, for instance, in one country, Iran, I believe it was, that they said in one summary that they barred J1, or that they barred J1 students, but instead, and I'm probably not saying it right, but anyway, there's a difference between J1 students and J1 exchange visitors. And so, no, that's what it was. Iran said they didn't. They accepted students, including F1, M, and J, but in fact, the J wasn't just the students, it was all exchange visitors under that category that were accepted, which is great because that's where physicians come to do their medical residencies and things like that. Professors come, visiting professors, things like that. So you just want to be careful when you're reviewing that you review the actual language and not just a summary if you're concerned about that. Now, there are exceptions to the current travel ban. And it's kind of nice because you don't have to read a court order to determine the exceptions. They're actually, at least not yet, there probably will be more court orders. But at this moment, you don't have to read a court order. You can determine the exceptions from the actual proclamation. So the exceptions are lawful permanent residents, green card holders, anyone already in the U.S. Now, be careful with that one. That doesn't mean that if you're already here, you can just travel willy-nilly and do whatever you want. I think what they're trying to say there is that they're not going to revoke your visa or do anything to you, not going to come get you or something like that if you're already admitted or paroled in the U.S. However, my understanding is if you leave and need to get another visa or need to enter, then you would be banned. So, be careful. People in those categories should not be traveling is the question, unless they would fall under one of these exceptions. Anyone entering with a travel document other than a visa. So, for instance, the advanced parole we talked about before, the advanced parole would work. And so, as long as it's not a visa, that isn't on the list. If the person has 2 or more nationalities, dual nationality, and they're entering on the non-banned country's passport. So, in other words, if you were, I don't know, Iranian and Canadian, dual national, you couldn't enter on your Iranian passport, but you could enter on your Canadian passport. Diplomats are exempted, and then people granted asylum, refugees already admitted, withholding of deportation recipients, or Convention Against Torture protection recipients. And so I think they put you know, so in other words, they could get, say, like a refugee travel document, I'm assuming from this language, and travel, and that would not be banned. It doesn't mean they could go necessarily. I mean, you know, I don't know if they could really get a visa or if they just have to get that travel document, but in any event, something they'll be fleshing out more. There are some waivers available as well, and the thing to remember about waivers is that, you know, it's great they have waivers, and it's nice if, you know, we can argue that for our clients. You certainly don't want to be in the situation of telling someone, oh, go ahead and travel, there's a waiver, because waivers are case-by-case basis. They don't have to be granted. They're in the discretion of either the consular officer or the SEVP, Customs and Border Protection. But, you know, if someone's in the situation where they've left or where they haven't entered yet and they want to try for the waiver, it's basically looking at undue hardship, no threat to national security or public safety, and the entry in the national interest. They've given us a very handy list of many examples that could theoretically fall into the waiver criteria. Now, I'm sure they would not say that just because they fall into this list that they're going to be granted. Maybe they will, but I would assume that they're going to look at this list and still have to say they have discretion whether or not to admit someone. And, you know, some of them are clear, like Canadian permanent residents, you are or you aren't, but some of the other ones are, you know, if you have a significant business or professional obligation and denial of entry would impair those obligations, well, what's significant, you know, and why would it be impaired? And that's the kind of thing that lawyers have to argue. But just to remind you, you're arguing that while your client's, you know, waiting outside the country, and if you don't argue that well, or if the consulate doesn't agree, they're not coming in. All right, and then just back to this refugee part of the executive order. Another part of the executive order limited refugee admissions to 50,000 for this year. The federal fiscal year ends October 1, so that also is expiring. Of course, the president has the right to say how many refugees will be admitted each year. In past years, usually it was more around, well, you know, it varies, but it's been around 60, 70, 80, sometimes more, thousand, we're talking, in past years, so and even more in some years. So the cut was significant last year. Department of Homeland Security has recommended the limit be 40,000 next year. Stephen Miller, who is the president's advisor on immigration, used to work, as I understand, for now Attorney General Jeff Sessions. So he's currently the advisor on immigration, and he's recommended 15,000 for next year. So we'll see where that comes in. And unfortunately, that could affect a lot of people in Iowa, because we do accept refugees, and we have programs that do that. So we'll have to see how that turns out. At any rate, I'm sure we're not done with the travel ban. I'm sure there will be more litigation, although I have to say this current version is going to be harder to litigate because most of the litigation before was based on the idea that it was a Muslim ban. Of course, they've added countries that aren't predominantly Muslim. They've articulated a basis for the travel ban in security and public safety. So I think this will be harder to litigate, but not saying that great litigators won't find a way to challenge this. And there's statutory authority for the president to limit admissions. However, the question is, does it really encompass what's going on here? And that's been the major argument on these, become the major argument on a lot of these cases, and that argument hasn't gone away. So, questions on the travel ban? Okay, you are not a curious bunch. That's okay. If you have questions, do feel free to jot those down, and we can come back to them. All right, now one of my favorites, Buy American, Hire American. This is another executive order that was actually issued April 18th. And I just have this graphic just to remind you this isn't the first time we've heard, you know, America first. And that's what really this executive order is based on. This executive order didn't get a lot of ink when it was put into effect because there were all these other things going on, like the travel ban, that took a lot of the air out of this particular executive order. But I've read it in full, and it's rather personally disturbing to me because it's based on the idea that immigrants are not good for the American economy and immigrants aren't good for the American worker. And so we want to do everything we can to encourage people to, and trade as well as far as that goes, because buy American is included there. So we want to encourage everyone to buy American, hire American, and the executive order basically said that he was ordering all the agencies to look at all their rules to determine how they could assist in that project. So that's what we're talking about with buy American, hire American. I don't know if anyone's going to start calling it Baja, but you know, I just did that so I didn't have to type it all the time. But anyway, we can call it Baja if we want to. Anyway, so I want to go through some of the agencies that have done something to effectuate this executive order. I'm sure we're not finished with this executive order. This will be an ongoing conversation. But the first one we can hit here is Department of State. So Department of State is, of course, separate from Department of Homeland Security, where all the immigration agencies reside. And it has its own rules, and those rules, sort of policy manual, sort of on-the-ground rules for the consular officers, is this Foreign Affairs Manual. And it's searchable, it's online, you can find it. The Foreign Affairs Manual has been updated by the Department of State to include this buy American, hire American language in all of its sections pertaining to work visas. And so it doesn't say specifically what they're supposed to do. It's just sort of as a reminder, when you're looking at this visa, you should consider whether it's going to be in line with this buy American, hire American. I haven't personally, thank goodness, had difficulty with this yet, but I have heard of practitioners that have had visas denied that they were very surprised about at the consulates, like L1 blanket visas, which usually are, you know, not easy by any means, but are fairly straightforward, denied. So it may be having an effect, or that may just be, you know, anecdotal. But eventually, as people are trained up, I'm sure that it will have the effect of limiting visa approvals. The other part of that, which is not just the buy American, hire American, but also goes to some of those security and safety type executive orders, is this idea of extreme vetting, which was, of course, mentioned in the campaign. And extreme vetting basically means, you know, it's not like we didn't vet before. Trust me, you know, if anybody's been involved in getting a visa for anyone, you know that there's a lot of vetting that goes on. Fingerprints and interviews and, you know, on, security systems in place. But the extreme vetting means that we just go back to, you know, sort of the immediate post 9/11, or, you know, something even more heightened scrutiny. So, you know, you've got to expect delays in visa issuance when anyone travels. Now, it doesn't mean everyone will be delayed, but, you know, it certainly can be a delay, and you need to expect that. Also, you know, interviews may be more in depth. It's tough, you know, because you're going up to a bulletproof glass window and pushing your documents under a little hole, you know, a little slit, and being interviewed for just a few seconds sometimes, or a few minutes. But the clients still need to be prepared, because if they don't really know their application, don't understand what they're supposed to be saying, you know, that now I think they will be scrutinized more than they used to be. And, you know, the consulates, they can change procedures. They don't have to notify anyone. There's not a notice and comment on that under the APA. So they can just change their procedures without notice. If you're sending people to consular process, it's important to look at the consulate and, you know, the website and that, and make sure you understand what is required, and what's, even if you've gone there before, you know, what's required, and to talk to people that have done it recently to know what's going on. All right, one important difference that now is in the Foreign Affairs Manual, excuse me while I take a drink here, is this idea of the 30-60-day rule is now the 90-day rule. So 30-60-day rule was, well, it all has to do with when someone applies for a visa, they make certain representations of what they're going to do when they get here. If they end up doing something that's inconsistent with what they said, the consulate can find, when the person goes back the next time, that they willfully misrepresented their intention. If they find a willful misrepresentation of a material fact in a prior visa application, they can deny you, not only deny you your visa, but find that you're inadmissible permanently, really, unless you have a qualified relative who could sponsor a waiver. And so it's a very serious thing if someone's found to have committed a willful misrepresentation. And it's not just at the consulate that this can happen. It can also happen if the person applies for something here. The Immigration Service, U.S. Citizenship and Immigration Service, USCIS, they can also find willful misrepresentation at the consulate or at the port of entry. They have their separate rules for how they do that, but they can also do that. So what is said at the consulate is important, and then what the activity is after. So the old rule was that if your inconsistent activity was within 30 days of entry, they would presume a misrepresentation unless you could overcome that presumption. If it was after 60 days, then there would be no presumption of misrepresentation unless there were evidence that there was misrepresentation. And in between that, it became kind of a sort of a gray area, but it wasn't it wasn't the presumption. It was just they could question it, but it wasn't as likely they were going to find misrepresentation. Now it's a 90-day rule. What that means is, you come in and you do something inconsistent, they're going to presume that you willfully misrepresented unless you can prove otherwise. So examples of that are unauthorized employment, enrolling in a course of unauthorized study, marrying a U.S. citizen and taking up residence, as long as, and again, I'll go back about the kind of visas here, but let's just say that. Any activity that would require a change or adjustment of status without the benefit of that change or adjustment of status. So in other words, what they're trying to say is, with this list, is that if you come in to do one thing, you decide to do something else, you can apply for a change of status, and if that's granted, you can do that something else. But if you just start doing the something else without a change of status, then you are, they're saying that you willfully misrepresented. Now, where this mostly comes up, it can come up in a lot of situations, but where it mostly comes up in my practice is marriage to a U.S. citizen. And the question is, did the person know at the time? I mean, you can get married, that's okay, but it's the taking up residence here that is the question. So if you got married here and then left and then processed your marriage visa through the consulate, that would be fine. But if you come, you decide you want to stay, the question is, did you have a preconceived intent to do that? So that is a lot of times the issue. And there is, and I think it's on the next slide, but I'll just say it here, there is BIA, Board of Immigration Appeals, a couple of cases that talk about normally if it's an immediate relative, the officer of immigration should just not weight that heavily that there could have been preconceived intent because of the desire to reunify families. They're generally going to balance that and equities and decide that you can go ahead and immigrate. But I wouldn't count on it too heavily, frankly. Now, it might continue, but I can see things changing. So I think we need to really think about how you're advising people. So the immigration has not necessarily adopted that rule, but we will look for that and see. Christy, is there a question? I see something beeping. No, something else. Okay, just making sure. All right. So they haven't necessarily adopted that, but they well may. Now, if the consulate finds that they get facts that tell them that you've done this, which sometimes they do because they actually have a lot of communication with immigration here at the consulates, the consular officer is supposed to cancel the visa. The fact that the visa is canceled doesn't in and of itself affect your status, but that's a bad sign. So if someone gets a notification, and they do notify people, they send them an email often or a letter. If you get one of those notices, that's something to take seriously because of the bad consequences of willful misrepresentation. All right, then we come to H-1Bs. H-1Bs are temporary professional workers. It's a common visa to use, although it is numerically limited. We have what's called the H-1B cap, and so if you've been involved in that, you know all the pain that goes along with it. We're only talking about 85,000 people a year, which is truly a minuscule number, but it does cause a lot of consternation. They issued a policy memo this year, March 31, that said basically, you know, a lot of the H-1Bs are in computer professions, and they said, well, not all computer programmers are eligible for H-1Bs because not all computer programming jobs require a degree, a bachelor's degree in a specialized field. And so they instructed the examiners at immigration to start looking at the wage level that was chosen for compliance with another part of this program that has to do with the Department of Labor. And they said if it was a level 1, there's 4 levels, and if it was a level 1, meaning entry level, that was an indication that the occupation may not be H-1B eligible. Well, we all read that and thought, well, you know, we can, you know, our computer jobs are you know, that we're filing for are more, you know, complicated than that. They're not, you know, it shouldn't be a problem. They're not computer programmers. Well, lo and behold, we all are now getting back these requests for evidence, and basically they're questioning every occupation to see if it's a level 1 wage, to say that they're not really professional occupations or specialty occupations because they're entry level. So, you know, I could talk about that for an hour itself, but I'm not going to because I don't know how many people that affects, but it's definitely a real concern right now for the people that are involved in that situation, and a real concern going forward about how, you know, what is the definition, why, you know, the way, just sort of the mind-blowing illogic of that, to say that, you know, you couldn't have an entry-level job that requires a degree. You know, people have gotten back for doctors, you know, and to say it just, that seems crazy. I'm sure those will get taken care of, but the ones that aren't as well-defined occupations, I think we're going to have to spend a lot more time analyzing those, making sure that we have a good case for those, and then looking at the wage level. And, you know, the wage level is supposed to, you know, entry level is a thing. There are, you know, entry-level jobs, but, you know, I don't know exactly how that will all play out going forward, but be glad to take more questions on it. So another thing they did on H-1B is they established an email address to report fraud so that people can do that. And they have intense scrutiny on computer staffing companies that use H-1Bs. And the reason I have the little Disney picture is because we can thank, well, Disney Corporation or whatever they're called for that, and along with a couple others, they engaged in activities that unfortunately were not illegal, but they unfortunately made it to the news, 60 Minutes and other news outlets, about what they were doing with staffing companies. So what they did was eliminate direct jobs in mostly computer-related fields, as I understand it, hired staffing companies that were utilizing H-1B visa holders to fill some of these positions, and basically made the U.S. citizens train their replacements who were not Disney employees. They were employees of the staffing companies contracted in. But still, you can imagine that that was not a happy day. And it, you know, shouldn't be a happy day, and I don't agree with that practice whatsoever. But it is legal at this point, at least, to contract for your jobs. And so that's one, I mean, it's been building for years, but those were perfect cases for them to then, you know, really make this an issue, and everyone, you know, understands that issue, and it's really big. So one of the things they're doing around that is more fraud detection visits. So there's this fraud detection and national security unit within the Immigration Service that will go out and do site visits to companies. And they're going to target more companies. This is usually around H-1B, but it can also be L-1s, but this particular is H-1B. And they said they're going to target employers whose business information is not available. So in other words, they Google you or they look you up on DUNS, I think it is, database, and if you don't show up there, then they could visit your site. Also, H-1B dependent employers, that means you have a bigger percentage, there's rules about who's dependent, of your employees. And so if you're H-1B dependent, you're also a target. And then employers placing H-1B workers at third-party sites, which are contractors. So if you're in those categories, you can expect that they will come, and you might not know if they can find you on Dun & Bradstreet, but you know, you could look yourself up, I guess, and see if they can find you. But they've not been able to find some of my bigger clients, so sometimes, you know, it doesn't, it's, you know, it's just sort of random. You could expect to have a site visit. Just a note about site visits, they are, you know, I don't know if they really qualify in a sense as law enforcement, but they're law enforcement-esque. And so you want to treat those like you would any other visit for law enforcement. Call your counsel immediately, make sure the counsel's there on the phone, or you can ask for your counsel to be there. Not required to answer questions without a lawyer present. If your client decides to go ahead with the visit, they can record the visit, take out their cell phone and start recording, or write the recollection immediately after the visit, or both. What they're really doing, and you know, a lot of times these are very low-key things, you know, they just want to come and see, is there the location, where's the person working, you know, is this really true? The problem with it is, and I have had this happen when clients have gone ahead with site visits without us there, is they can turn out to be huge misunderstandings in which the visas then, you know, the H-1B is then revoked, or they give you a notice of intent to revoke because of misunderstandings that occurred when they're talking to someone who, you know, doesn't remember what was in the application, or answers some question in a, you know, way that makes sense to them but not to the examiner. And so, you know, it's something just to be careful. The other thing I think we're going to see is more LCA audits. So Department of Labor audits those, but I think I could see that happening. So I think LCA files, and if you don't know what those are, then they have to do with the Department of Labor part of the H-1B. And then the other thing I could see, the direction I could see them going, is co-employment, looking at co-employment and trying to say that that not only are these employees of the contractor, but also of the main companies. Like in the Disney situation, they were employees of whoever the contractor was, and Disney. And there's a lot of good precedent for that in the employment law. And if they make that argument, then, you know, this becomes a totally different discussion. I don't know if that'll happen. I'm just kind of guessing. Okay, more things. Immigration Service has been so busy. They refused to implement the Immigrant Entrepreneur Rule. There's now a lawsuit about that. They're also interviewing almost all adjustment of status applicants now. They used to waive interviews in employment-based and other situations, but they've said they want to interview everyone in person. So this will mean delays in green card issuance. If they really do it, it could be, I don't know, years. I'm not sure. It'll be a long time. So it means people could file for the green card, but then not get their green card for a long time. If they do that, I suspect we'll have the waiting lines will change, will actually decrease because there won't be the usage of the visas. And so that could be a silver lining for people from Canada, China. Maybe they'll be able to file sooner for their green card, which could be good, although, you know, then everyone might be in line for years for their green card, like the poor people from India and China are now. And, you know, they can renew work permits and do various things, but you know, it's just make it a longer and more arduous process. So that means we should consider consular processing as an alternative for our clients. You know, that could become more difficult too, but I think it's something that we need to, you know, we need to think about. Okay. All right, just a quick word on I-9s. There is a new version out. You should be using that now. September 18th was the first day. It was a very small update. They may put out another version soon, but interestingly, they deleted the old version from the website when they put out the news, so I thought that was interesting, made it a little hard to compare, but in any event, that's happening. The other thing in terms of employment and this whole Buy American, Hire American that you should be aware of is the Immigrant and Employee Rights section of Department of Justice, which used to be called the Office of Special Counsel. They've always had this focus to some degree, but they're more and more we expect they'll turn their focus to sort of the reverse discrimination situation, which is saying that a company hired foreign workers and disadvantaged U.S. workers. And they've said so much on their website, but also there have been a couple cases that I have in the slides. Now those were H-2B and H-2A cases where they said that U.S. employees were disadvantaged or applicants were disadvantaged. Now in both H-2A and H-2B, you have a recruitment requirement. H-1B, you don't have a recruitment requirement, so it'll be interesting how they make that case that you disadvantage the U.S. workers, but they'll be trying, I think. So you want to document your hiring process and make sure those records are retained when you do end up hiring an H-1B. Doesn't mean you can't hire an H-1B or that your client can't, but I think it needs to be a little more careful. Then we go over to ICE, Immigration and Customs Enforcement. They are the ones that actually audit I-9s. Again, I think this co-employment issue could be one way they try to address some of these things and say, well, gosh, it's a co-employment, if your contractor didn't have I-9s done right, you could be responsible for that. That's just speculation, but it could happen. All right, and then I know we're running out of time, but I did just want to alert you that the ICE has, of course, ended their prosecutorial discretion. So we're seeing more visits, we're seeing more people, not that, I mean, they've always been enforcing, but they're enforcing in a bit of a different way now and picking up people that just happen to be there, which again has happened all the time, but I think more so. So one thing to think about is, the difference between an administrative warrant and a judicial warrant. That you have the right to counsel. If it's just an administrative warrant, they do not have the ability to go into private spaces, and so thinking about marking private spaces, and again, not because you're trying to hide anyone, but just because of, it's like you have a restaurant or something, how's that work for your business for that to happen? And so you want to avoid obstruction of justice in that effort, but still something to think about. Now, the sensitive location memo is still there, where they say they won't go into schools and medical treatment, healthcare facilities, churches, etc. However, courthouses are not sensitive locations, and people are getting picked up there all the time. And there are exceptions to the sensitive locations memo that they can use to still go into those places. And the memo does not cover it only covers enforcement actions, not records requests and things like that. So what you want to make sure your clients understand is the privacy ramifications of giving information to law enforcement. If they have a subpoena, usually that's fine. But if they don't have a subpoena and they've come to your school or whatever, you need to just think about the I-9 does, and some other records do have some personally identifiable information, or can, and whether you should be giving those away in a certain situation is something to really think about. The other thing that now with this increased enforcement is really planning for the worst, which means planning for if someone is deported. And I know our lawyers in our estate planning department have put together a packet, but there's need to make sure how are people going to be handling their kids, their assets, and notarios are having them sign documents that we don't think are enforceable. And so let people know that you need to talk to someone who knows what they're doing to make sure that it's going to be effective. And just a reminder to watch the legislative front. We have some very, what I would call bad bills out there, and And they are something that boy, I don't know what will happen if they do something like this. But I think well, I'll just tell you about some of these bills. So the RAISE Act is a bill that's in the House, and it's got a companion bill in the Senate. If anybody's been watching this issue, oh wait, I'm so sorry. Before I breeze through to legislation, I got on a roll there. Let me go back. I went through some of that a little bit quickly on the both the Buy American and Hire American. I should have given you a chance to ask a question there. So let me just quick go back to that. Any questions on the Buy American, Hire American? Not yet. Okay. All right. Well, I'm glad that I'm covering all the things, and I did, just because I did breeze through on that. I do want to just quick go back to make sure I was clear about that third-party liability just for a second, because I just realized as I kind of got going there on a roll. The idea of this co-employment idea, I think, could come up in two different situations. So one is with I-9s, and that already does come up sometimes in the case of when you have a now I'm going to forget the name, but like a payroll company, that sometimes they actually hire the employees and they do all your payroll aspect. And so that's something where if one of you, either you or your payroll company, is going to have an I-9, and you need to decide that in your contract. So they've kind of got that already. But what I'm thinking about is when, if they let's say you've got, because I know ICE has said they want to go after H-1Bs, if they want to try to figure out some way to see if they can stop this H-1B contracting, they could go in and say, okay, we want to audit your I-9s. Who are these people on site that you don't have I-9s for? And you say, well, those are consulting contractors that are employed by XYZ company. And they say, well, let's go through the indicia of employment, and it looks like you really are controlling them. You should have I-9s for them. And you say, oh, no, XYZ company is taking care of that. We'll go get their I-9s. And what if they don't have them? Or what if they did them wrong? Now, I'm sure these people are authorized to work, because these companies seem to be, careful with that. But whether they know all the I-9 requirements or not, I don't know. So some companies now are, and I think it's a great idea, if you have consulting companies on your, consulting companies working on your site, you could have a provision in the contract that they need to attest that they have the I-9s, or perhaps you want to review the I-9s, or you want someone else to review the I-9s. Walmart's been doing that for a long time with their contractors, because they had a really bad situation many years ago on this, where they were going to be fined a lot of money and settled for a lot of money. Not a lot of companies have implemented that, but you want to think about that. Think about how that would affect your operations. Think about if it's a good idea to actually review them, or if a third party should review them. Something like that if you're using computer contractors, because I can see this as an area of real focus. The other place I think that would come up is in the LCA liability. So LCA labor condition application, it's the part that you fill out for Department of Labor when you do an H-1B. Again, not audited a lot. It's usually in reaction to a complaint, but still, if with that liability, if they're going to start looking at co-employment in that situation, perhaps that would start to bleed over as well into the consulting client, so to speak, company. And one of those requirements is to post a notice at the job site And I know, we tell our H-1B employers that staff, post this on your client's site, but sometimes that's very hard to get done. So if they haven't got that done, now, who knows what that will be. So again, not trying to scare anyone away from using H-1Bs or scare anyone in general, but just letting you know that they are really trying hard to figure out how to not have these computer contracting H-1Bs, even though it is a legal profession in the country, a legal business, so to speak, in the country. And so they're going to do things like that on those. So anyway, I digress, but I just wanted to make sure I did that. Any questions on that, or did you think of any other questions on the Buy American, Hire American? Nope, Christy keeps shaking her head at me. Okay, so, and I did kind of breeze through the ICE part too about, the sensitive locations and the increased enforcement. So I just wanted to make sure I didn't leave anyone out of a question there either. Okay, so, and just to say there, also, we're not assuming that anyone's, anyone who thinks they have unauthorized workers needs to address that in any event. It's not legal to hire. If you're not legal to hire, and if you know that, you're going to be in trouble for that. But there's a lot of great fake documents out there. You don't have to fully investigate a document to make sure that it's legal. I mean, it's supposed to be genuine on its face and relate to the person in front of you. And so in that regard, you don't always know who's in the workforce. You can certainly audit I-9s, and I think that's something more companies may be doing, is auditing I-9s. But if there's no requirement to audit your I-9s or to use E-Verify or to do any of those things, there's no requirement. That's why I think it's prudent for employers, particularly in certain areas, to realize that they may have workers that aren't authorized to work even though they don't know that. And what would that effect be on their business if they have an inspection of their I-9s, or if they just have ICE coming in and asking, usually they come in to look for one person and then they'll turn around, oh, well, give me your documents, give me your documents. And they're taking people in that situation as well. Something that businesses need to plan and need to think about and decide how they want to approach that. So it's not not just a concern for the workers, which is of course a huge concern. We have people who are related to U.S. citizens, a lot of U.S. citizen children who have one or two undocumented parents. So I think it's going to be terrible in many respects, but in terms of the business side of it, it's also going to be something. I've already had one business that found out they had workers that weren't supposed to work, and they ended up just closing because they didn't know, they couldn't get other workers anywhere else. When I called the ICE officer about and told him that, he felt really bad, but I think, well, that's the way the world is right now. That's just what's going to happen. So I think we'll see things like that. Okay, so any questions about the ICE enforcement before I finish up here? Okay, so on the legislative front, the RAISE Act has been introduced by, I think it was Cotton and Perdue, are the House members. And then they have the companion bill in the Senate with our friend Lamar. Let's see, Lamar's in the House. No, Lamar's in the Senate. Okay, well anyway, some of the players you may have heard if you've been following this issue for a long time are back, and they have proposed this legislation called the RAISE Act. Basically would cut immigration in half in all aspects over the next few years. What they are selling it as is more employment-based visas, fewer family-based visas, and they use the term chain migration and things like that to talk about family-based visas. So, because right now our system's about 3/4 family-based visas. So they cut those, and they would relatively increase the employment-based visas, but still it would be cut in half, so it's still lots less immigration. It would be a point system where they have their criteria, and you have to check mark and see how many points you would have. And this legislation has been endorsed by the president and his advisor, Stephen Miller. So I think it's more, I don't know that it would necessarily pass. I mean, a lot of people were very, you know, not supportive when it came out, and there hasn't been a lot about it lately with all the other things going on. But I think it just indicates the direction that things are going and what needs to be done if you or your clients think immigration is a good thing for them, that they really need to speak up at this point. And I have particular concern for rural areas like, you know, in our state and others, agriculture, and, you know, even Midwest cities that really rely in a lot of cases on immigrant workers to fill needed jobs. And I think if you go through the point system, it'd be pretty hard for a farmhand to immigrate. Now, they do talk about they might affect or they might introduce something. There's been some talk of introducing some kind of agriculture-related bill. But we haven't really, I mean, there's something out there, but it hasn't gained a lot of traction. That might, you know, that might help in that situation, and that would be for temporary workers. But in terms of, you know, in terms of immigration, in terms of really addressing people that are here and, you know, solving that particular situation for people in our state, I think it, you know, I think it's unlikely. So anyway, you know, takeaway there again, and I don't, you know, just whatever your position is on it, this is the time to be talking about it. Even though it may not seem like it's really in the news right now too much, I think that things are percolating under the surface, and Senator Grassley is the chair of the Judiciary Committee. That committee controls immigration legislation. Senator Ernst is very interested in the issue as well. And of course, our House members, all but one, are Republicans, so they are, you know, the majority party, and they definitely need to be contacted to let them know the true stories of what's out there and how, you know, the current situation really would affect us. So, any questions, Christy? We have a question. All right. Christy's going to come up and help us with her question. Okay, so how will these laws, executive orders, impact things like healthcare in the United States? Good question. You know, we are quite dependent in Iowa, particularly on foreign doctors. Nothing that has happened so far has particularly addressed that situation, but it is a deterrent for people coming from certain countries, of course. And like I said, they did exempt from Iran, they exempted J1, so that means doctors could still come, but doctors, say, from some of the other countries where there's bigger exception would not be able to come here to get their residencies. And so that's one effect. The H-1Bs, even though doctors have been included in that, that situation with level 1 wages, I don't think that's going to stand. So I think that'll be okay for doctors. But nurses are certainly at risk because not all nursing professions do require a bachelor's degree, and that's been something we've been going back and forth on for years. There still is some ways to help nurses. Already, we have some issues with trying to staff our healthcare areas with, we don't have visas for CNAs or, things like that. What we're afraid of and seeing somewhat is just talented people not wanting to come to the U.S. So I don't think it's going to be good for healthcare, but we don't really know for sure. And then the other question was the industry concern was agriculture, and I mentioned a little bit about that, but absolutely agree. Anecdotal evidence, or maybe not so anecdotal evidence, suggests that anywhere between 50 and 75% of farm workers in the in the animal-related industries are not here working legally. Now that could be inflated, that could be low, I don't know, but there's a lot of problems out there with that industry. If enforcement reaches to those areas, I think it will be devastating for agriculture, and we need a fix. We absolutely need a fix on that, because no one wants to hire workers that aren't legal to work. It's just that there aren't other workers available, and so it's a real problem, and it needs to be addressed. So thank you for those questions. Okay, well, I think we have another one just one more. Are employers legally required to report to ICE about potentially fraudulent documents required? You are not required to report those. You, of course, if you know the document's fraudulent, obviously don't accept it for I-9 purposes. You can report, anyone can report anything to ICE that you want to, but there's no requirement to report. There's just a requirement not to hire. Good question.